In February, when blockades and occupations across the country endangered public safety, disrupted our economy and hurt workers and their families, our government made the decision to invoke the Emergencies Act. Invoking the Emergencies Act was a decision that was taken only after careful consideration and with significant and appropriate caution. We also continually reassessed that decision to ensure that the Act was only in place as long as was necessary. And when we revoked the Act, we spoke about the reviews that would follow, including the necessity under the legislation of conducting an inquiry. Today, we are announcing that we have established the Public Order Emergency Commission, an independent public inquiry that Justice Paul Rouleau will serve as Commissioner. As a commission established pursuant to the Inquiries Act, the Commission will operate at arm's length from the government, and it will conduct its work independently. The Commissioner will have all of the powers and authorities granted to him under the Inquiries Act. And for example, the Commissioner will have the power to summon before him as witnesses and require witnesses to give evidence orally in writing and to produce such documents as things that the Commissioner may deem requisite to the full investigation into the matter to which he is appointed to examine. I believe the Canadians can have great confidence in the work Justice Rouleau will do with the tools and mandate that he has been given to examine both the circumstances that led to the emergency and to the measures that were taken to bring it to an end. I'll now invite my colleague, Minister Mendicino, to say a few words.
Thank you very much, Bill. And today is a landmark day because we will be fulfilling our obligations under the Emergencies Act to commence this public inquiry. We want to begin by expressing our gratitude to Justice Rouleau, who is a sitting judge on the Ontario Court of Appeal, who has a plethora of experience in understanding the issues which will be brought before him in the context of this public inquiry. As Minister Blair said, we're looking forward to cooperating with Justice Rouleau to ensure that he has the access to the information, including classified documents, so that he can do his job. Also just underline that there are some procedural requirements to file the report to the conclusion of this public inquiry within 360 days of the expiry of the revocation of the Emergencies Act, which is February 20th, 2023. And we're looking forward to it. This is not just about checking a box off. This is healthy for our democracy, and we want to thank the Commissioner ahead of his important work, and I'll turn it over to Minister LeBlanc. Thank you very much.
Merci. Comme mes collègues ont bien exprimé, en février, lorsque les blocus et les occupations à divers endroits du pays ont menacé la sécurité publique, perturbé notre économie et heurté les travailleurs et leurs familles, notre gouvernement a invoqué la loi sur les mesures d'urgence. La décision d'invoquer la loi sur les mesures d'urgence a été prise après mûre réflexion et avec beaucoup de prudence. Nous avons aussi continuellement réévalué cette décision pour nous assurer que la loi n'était en vigueur que pour la durée nécessaire. Et lorsque nous avons révoqué la loi, nous avons évoqué les examens qui suivraient, y compris l'enquête que nous annonçons aujourd'hui. Et aujourd'hui, nous annonçons cette enquête que nous avons créée. Nous avons créé la commission d'urgence sur l'ordre public, une enquête publique indépendante, et que le juge Paul Rouleau sera le commissaire. Les Canadiens peuvent avoir confiance dans le travail que fera le juge Rouleau avec les outils et le mandat qui lui ont été confiés pour examiner à la fois les circonstances qui ont mené à la situation d'urgence et les mesures prises pour y mettre fin. L'honorable Paul Rouleau est un juriste, comme mon collègue le ministre Mendicino a indiqué, un juriste distingué d'une longue expérience qui a acquis cette expérience à la Cour d'appel de l'Ontario et aussi aux cours supérieures de l'Ontario. Et sa longue feuille de route et ses compétences lui seront très utiles en tant que commissaire de cette enquête. Et finalement, un élément essentiel de ces enquêtes, la Commission fonctionnera de façon autonome et indépendante du gouvernement. Merci.
Minister Mendicino, in retrospect, it was overreach to invoke the Act. And would you do it again, like considering for this weekend the Rolling Thunder protest? Would you use this tool again?
Well, I think we can be unequivocally clear about a number of things looking back in the events of January and February of this year. One, the incredible and devastating damage that was done to public safety at ports of entry in the form of interruption to trade and travel, the interruption to supply chains, including with regards to vital health supplies, which Canadians needed on a daily basis, the disruption to public safety in our communities, in our neighborhoods, and the unique and unprecedented challenges that these illegal occupations and blockades posed. And it was only after very careful consideration on the advice of professional, nonpartisan branches of law enforcement that we invoked the Emergencies Act. It was a necessary decision. It was a responsible decision. It was the right thing to do. And we are certainly looking forward to cooperating with Justice Rouleau in the context of this public inquiry so that he has the fulsome record, as well as the Joint Parliamentary Committee, which is looking at this at the same time. Sorry?
Will you have full access to cabinet documents?
So on that issue, I will say, as Ministers Blair and Mr. LeBlanc said, that pursuant to the Act, the judge, the Order in Council, that the judge will have broad access, including to classified documents. Our intent is to collaborate with the judge so that he has a fulsome record, so that he can do his job. Pardon? Je vais prendre une question en français.
Deux questions. Si vous dites qu'il va y avoir un grand accès au Conseil des ministres aux documents, est-ce qu'il va y avoir accès à tous les documents ou à beaucoup de documents? C'est une différence.
Je sais. Je comprends la distinction et c'est une décision pour le juge. Et le juge va faire son travail dans un niveau qui est indépendant, impartial. C'est un processus qui a beaucoup d'intégrité et je ne veux pas préempter le travail de le juge.
Why is it in legal challenges that cabinet confidences have been cited as a reason for the federal government to not reveal its decision to invoke the Emergencies Act?
Well, I think it's important to distinguish that process from the process that we are launching today under the Act. There is litigation that is before a separate judge, a separate court, involving different litigants, and obviously will be up to that tribunal and that judge to make determinations about what access is required. What we are launching today is a public inquiry in fulfillment of our obligations under the Emergencies Act. And what I'm saying to you and to others is that our intent is to ensure that the judge has access to the information that he needs to fulfill his responsibilities under the parameters which have been set under the Order in Council. And we would point out that the parameters are there to guide the judge, but there is discretion there, including with regards to compelling witnesses, compelling documents, including classified information.
So what information will be made public?
So the question is, what information will be made public? That is a very important question which should be posed to Judge Rouleau. Today is the beginning of the process. It's not even the middle of the process, nor is it certainly the end of the process. And one of the hallmarks of this public inquiry is that he will have the capacity to function independently, impartially from the government. And it's one of the reasons why the government chose to make this a fully blown public inquiry, so that he could have the independence to make those decisions. Ministre LeBlanc.
Excusez.
Quel sera le budget du juge Rouleau pour ses activités, pour ses employés, pour ses témoins? Et est-ce que le gouvernement s'engage aussi à donner toutes les sommes demandées par le juge Rouleau éventuellement?
Nous nous sommes engagés, évidemment, à donner au commissaire et à la commission toutes les ressources nécessaires pour remplir leur mandat important. C'est déjà prescrit dans la loi un délai d'1 an, d'un peu moins d'1 an maintenant. Alors, nous comprenons l'urgence d'agir vite, nous comprenons le besoin de s'assurer que toutes les ressources nécessaires que le commissaire va demander seront disponibles pour lui. Et peut-être pour répondre à une autre question, évidemment, le rapport sera public à la fin de l'exercice. D'ailleurs, l'ordre en Conseil prévoit que le rapport sera déposé devant les 2 chambres du Parlement, précisément pour s'assurer que le rapport du juge Rouleau sera connu par tout le monde et sera public.
Mais combien vous mettez sur la table?
Mais-
C'est quoi la somme?
Ben, c'est une discussion, évidemment. Il y a des normes selon le Conseil du Trésor. Ce n'est pas la première enquête qu'on a vue de ce genre de circonstances. Il y a des façons que la Commission va interagir avec le Conseil privé et surtout le Conseil du Trésor. Mais l'instruction du Conseil des ministres, c'est de donner à la Commission toutes les ressources nécessaires. Et le commissaire n'a pas commencé son travail. Dès qu'il commence et il arrive devant le gouvernement avec des demandes de ressources, on va être là pour s'assurer qu'il y a tout ce qu'il y a besoin.
What was your thinking about tapping?
The recommendation, what comes out of this inquiry, it's not legally binding, correct? These are recommendations. Is that correct? So if they're recommendations, what kind of impact will this have if it's not legally binding?
Well, I think our government has a very strong track record at taking very seriously the recommendations which are put forward by independent public officers. And it is precisely because this is a process that does imbue into the judge independence, impartiality, the power to get access to the information and the people that will provide him with a fulsome record to examine the circumstances that led up to the invocation of the Emergencies Act, as well as potentially making important policy recommendations and legislative recommendations, should he so choose, to ensure this never happens again. And having had to live through what was an extraordinarily difficult time for Canadians across the country. I mean, I spent the last 2 weeks going to British Columbia, speaking not only with frontline law enforcement officers, to whom we owe a great debt of gratitude for their work in restoring public safety so that we could get trade and travel going again, so that we could get our economy going again, including here in Ottawa, where for those who live here, this town was under, it's hard to describe just how difficult that moment was for residents. But that's why the recommendations that will be put forward by Justice Rouleau will be taken very seriously by this government.
What was the thinking about
involvement in preparing for the motorcycle convoy that's coming this weekend? Are you involved at all in the plan?
Well, we're aware that there are some reports that there may be another convoy making its way to Ottawa, and certainly I think coming out of the blockades in January and February, that there are lessons that are being incorporated into law enforcement, chief among which is the need for collaboration and open lines of communication among various levels of police services, which is why, again, today's launch of a public inquiry, which will be led by Justice Rouleau, is important. It is important that we take some lessons from the blockades and the occupation, and I know that that's work that he's going to undertake with great attention.
What was the thinking about tapping a current jurist as opposed to a former judge for this role?
Well, as Minister LeBlanc and Minister Blair said, Justice Rouleau has a depth of experience, both as a trial judge in the Ontario Superior Court, as well as a sitting judge of the Ontario Court of Appeal. He is well respected and brings with him, I think, the capacity to undertake this review with all of the impartiality, all of the independence, all of the integrity, so that Canadians can be confident that the Emergencies Act was a necessary tool and one that will ensure that we keep our Canadians safe and healthy going forward. Merci beaucoup.
Independence, though, is this just looking at what led to the Emergencies Act, or is the judge going to be able to say, you were right or you were wrong to invoke the Emergencies Act?
Well, it calls for an examination of the circumstances that led to the invocation of the Emergencies Act, but it also allows him the scope to take a look at, for example, the objectives and the goals of those who were agitating the illegal blockades and the occupation, to take a look at issues that relate to funding, to take a look as well at potential recommendations which we may need to materialize in the form of new legislative tools. And certainly there is a space there to have a discussion, a robust discourse about whether or not we need some new tools, and we look forward to receiving the report.
Are you reserving
I
the
think
right
that's it.
to
Merci
withhold
beaucoup.
documents from this inquiry?